Security. Remove this man immediately. He clearly doesn't belong in a law firm of our caliber. The command rang through the marble lobby of Sterling and Associates as Senior Partner Victoria Walsh pointed at the black man in khakis and a button-down shirt. She looked at him with pure contempt, completely unaware she was ordering the removal of David Sterling, the managing partner whose grandfather had founded the firm bearing his family name. Let me take you back to 4:15 p.m. on a humid Thursday afternoon in Manhattan's legal district, where assumptions about belonging would destroy careers and expose the ugly truth about discrimination in America's most prestigious law firms. Sterling III carried the weight of 3 generations of legal excellence on his shoulders, though he wore it with the quiet confidence that came from earning rather than inheriting his position. At 49, he was the managing partner of Sterling and Associates, one of New York's most prestigious law firms, founded by his grandfather in 1923 and built into a legal powerhouse through decades of landmark cases and brilliant advocacy. But David's path to leadership hadn't been automatic or easy. Despite bearing the family name, he had been required to prove himself at every step. Harvard Law School, summa cum laude. Harvard Law Review, editor-in-chief. Federal clerkship with Supreme Court Justice Ruth Bader Ginsburg. 23 years of brilliant legal work that had earned him respect throughout the profession. Sterling and Associates had grown under David's leadership from a respected firm into a legal empire. They represented Fortune 500 companies, argued cases before the Supreme Court, and handled mergers and acquisitions worth billions of dollars. The firm's 200 attorneys included some of the brightest legal minds in the country, and their win rate in major litigation was legendary. More importantly, David had transformed Sterling and Associates from a traditional white-shoe law firm into an institution that actively recruited diverse talent and took on pro bono cases that advanced civil rights and social justice. Under his leadership, the firm had become 40% minority-owned and had established a reputation for using its legal expertise to create positive social change. Today's visit to the firm's offices was unplanned. David had been in court all morning arguing a federal appeals case, and he had changed out of his formal court attire into business-casual clothes before stopping by the office to review case files. He wore khakis, a navy button-down shirt, and leather loafers, the kind of understated professional attire that successful lawyers wore when they didn't need to impress anyone. What David didn't expect was that some of his own staff wouldn't recognize him outside of his usual 3-piece suits, and that his casual appearance would trigger assumptions about his right to be in the building he owned. Sterling and Associates occupied 4 floors of a pre-war Manhattan building that exuded old-money elegance and legal prestige. The lobby featured marble floors, hand-carved woodwork, and portraits of distinguished attorneys dating back to the firm's founding. Everything was designed to convey competence, tradition, and the kind of exclusive access that came with hiring the best legal representation money could buy. The reception area on the 32nd floor was staffed by perfectly groomed assistants who managed appointments for the firm's senior partners. Clients included tech billionaires, pharmaceutical companies, real estate developers, and politicians who needed legal expertise that could navigate the most complex challenges. David's grandfather's portrait hung prominently near the main entrance, and the firm's history was displayed in glass cases that showcased major victories, landmark cases, and recognition from legal organizations. The Sterling family legacy was woven into every aspect of the firm's identity and reputation. But as David walked through the lobby that Thursday afternoon, none of the staff seemed to recognize the connection between his appearance and the family name that defined their workplace. "May I help you?" The receptionist's tone was polite but slightly puzzled, as if she couldn't imagine what business a black man in casual clothes might have at Sterling & Associates. "I'm here to review some case files. David Sterling." The receptionist checked her computer, frowning slightly. "I don't see any appointments scheduled for a David Sterling today." "I don't have an appointment," David explained. "I'm a partner here." The receptionist's expression shifted from confusion to skepticism. She had worked at Sterling & Associates for 3 years, and she knew all the partners, or thought she did. None of them looked like the man standing in front of her. "Sir, I think there might be some confusion. All our partners are listed in our directory, and I don't see anyone by that name who matches your description." The pause before description was telling. David realized that the receptionist was diplomatically trying to say that none of the firm's partners were black, which was both factually incorrect and deeply troubling. Before David could respond to the receptionist's confused dismissal, Senior Partner Victoria Walsh emerged from the elevator bank. At 56, she was one of Sterling & Associates' most successful litigators, known for her aggressive courtroom tactics and her unwavering commitment to winning cases for the firm's wealthy clients. Victoria had joined Sterling & Associates 15 years earlier, recruited from a competing firm with the promise of partnership track and high-profile cases. She had built her reputation on corporate defense work, helping companies avoid liability in discrimination lawsuits, environmental cases, and financial misconduct proceedings. Her specialty was making problems disappear through legal technicalities, aggressive motions practice, and settlements that prioritized her clients' interests over broader considerations of justice or accountability. She was exactly the kind of lawyer that gave the profession a reputation for protecting the powerful at the expense of everyone else. When Victoria saw David talking to the receptionist, her institutional radar immediately activated. She saw a black man in casual clothes who appeared to be claiming some connection to the firm, and she made the same biased assumptions that had guided her entire career. "Is there a problem here, Jennifer?" Victoria asked the receptionist, her tone suggesting she was prepared to handle whatever unpleasant situation had arisen. "This gentleman claims to be a partner, but I can't find him in our directory," Jennifer replied, clearly relieved to have senior support in dealing with what she perceived as a difficult situation. Victoria looked David up and down with the kind of assessment she used in depositions, calculating, skeptical, and designed to identify weaknesses she could exploit. "Sir, I don't know what kind of misunderstanding has occurred, but I can assure you that you are not a partner at this firm. We know all our partners, and you are definitely not one of them." David felt the familiar chill of discrimination dressed up as professional authority. "Actually, I am David Sterling, managing partner of this firm, and I think we need to discuss why your receptionist doesn't recognize the names of our partners." Victoria's laugh was sharp and dismissive. "David Sterling? Sir, that's impossible. The Sterling family founded this firm, and I can assure you that you're not a member of that family." The racist assumption was clear. She was rejecting David's identity entirely based on his race, unable to conceive that a black man could be part of the founding family of a prestigious law firm. "Ma'am," David said, his voice remaining calm despite his growing anger, "I understand there might be some confusion, but I am exactly who I said I am. Perhaps we could resolve this by calling my office or checking the firm's partnership agreements." Victoria's expression hardened. She had dealt with people who tried to bluff their way into exclusive circles before, and she wasn't falling for whatever game this man was playing. "Security, remove this man immediately. He clearly doesn't belong in a law firm of our caliber." The security call echoed through Sterling & Associates' lobby like a legal brief being filed, official, final, and devastating in its implications. Every conversation stopped. Every head turned. The distinguished atmosphere of legal professionalism was shattered by the spectacle of a black man being publicly ejected from the firm. David felt the weight of 60 years of family history crashing down around him. This was the lobby where his grandfather had greeted clients who needed the best legal representation available. This was the firm where his father had argued cases that shaped civil rights law. This was the institution that bore his family name and carried their legacy of legal excellence. And now he was being thrown out of it like a trespasser. "Sir, you're going to have to come with me," the security guard said apologetically, clearly uncomfortable with the situation, but following the orders of senior management. "Before you escort me anywhere," David said, his voice carrying the authority that commanded respect in courtrooms across the country, "I need to make a phone call." Victoria rolled her eyes. "You can make all the phone calls you want from the sidewalk. This is private property and you're trespassing." David reached into his pocket and pulled out his phone, dialing his executive assistant's direct line. "Margaret, it's David. I need you to conference in legal and HR immediately. We have a code red situation at the main office." Margaret Chen, David's executive assistant for 8 years, responded without hesitation. "David, what's wrong? You sound upset." "Margaret, I'm standing in our lobby being threatened with removal from security because Senior Partner Victoria Walsh doesn't believe I work here." The silence on the phone was deafening. "She said what?" "Miss Walsh has called security to remove me from the building because she doesn't think I belong at Sterling & Associates." Victoria was watching this conversation with growing unease. The man she was having removed was speaking with the kind of calm authority that suggested important people took his calls. "Margaret," David continued, making sure his voice carried clearly through the lobby, "I need you to pull the firm's partnership agreements, the founding documents, and my grandfather's original incorporation papers. I also need you to get the senior partners on a conference call immediately." "David," Margaret said, her voice tight with concern, "I'm pulling those documents now. And I'm calling an emergency partners meeting. This is going to be a disaster." David's phone buzzed with an incoming call from the conference line. He answered it and put it on speaker. "David, this is Richard Hayes, senior partner. Margaret briefed us on what's happening. Are you all right?" The voice was loud enough for everyone in the lobby to hear, and the tone of respect and concern was unmistakable. "Richard, I'm standing in our lobby where Victoria Walsh has called security to remove me because she doesn't believe I'm a partner at this firm." There was a long pause on the phone. "She said what?" "She rejected my identification, claimed I couldn't possibly be David Sterling, and ordered security to escort me from the building." "Victoria Walsh, are you there?" Richard's voice had taken on the dangerous edge that courtroom opponents learned to fear. "Yes, sir," Victoria managed to whisper. "Victoria, could you please explain to me why you're having our managing partner removed from his own building?" The words hit like a legal ruling that couldn't be appealed. Victoria's face went from confident to confused to horrified as the reality of her mistake became clear. "Sir, I had no idea." "Of what?" Richard interrupted. "No idea that David Sterling is our managing partner? No idea that his family founded this firm? No idea that he's been leading this organization for the past 8 years?" Victoria looked like she might faint. I assumed." "You assumed that a black man couldn't be a Sterling family member? You assumed that someone who looked like me couldn't possibly be a partner at this firm? You made those assumptions without asking for identification, without checking records, and without considering that your prejudices might be wrong." The phone crackled with another voice. "David, this is Catherine Morrison, head of HR. I'm documenting this entire incident. Victoria Walsh, you're suspended from your position effective immediately." "Wait," Victoria said desperately. "If I could just explain." "There's nothing to explain," Richard replied coldly. "You've discriminated against our managing partner based on his race. You've created a hostile work environment, and you've demonstrated exactly the kind of bias that we've worked for years to eliminate from this profession." Within 30 minutes, Sterling and Associates had been transformed into the scene of a corporate crisis that threatened the firm's reputation and relationships. Senior partners who had been in court or meetings were called back to the office. HR representatives were pulling personnel files and policy documents, and Victoria Walsh was clearing out her corner office under the supervision of security. David found himself in the surreal position of having to prove his identity and authority to his own employees. He provided his bar license, his partnership agreements, and his grandfather's founding documents to staff members who were struggling to process what had occurred. "Mr. Sterling," Jennifer, the receptionist, said, her face flushed with embarrassment, "I am so sorry. I had no idea who you were." "Jennifer, that's exactly the problem. You couldn't imagine that a black man might be a partner here, so you didn't even consider checking the records that would have confirmed my identity." The investigation that followed revealed troubling patterns throughout Sterling and Associates' corporate culture. Despite David's efforts to diversify the firm, unconscious bias had persisted in ways that he hadn't fully recognized or addressed. Review of client interaction records showed that potential clients of color were often directed to less experienced associates rather than senior partners. Fee structures were applied differently based on subjective assessments of clients' ability to pay. Business development efforts had focused almost exclusively on traditional networks that excluded minority-owned businesses and diverse legal professionals. Most damning of all, the investigation revealed that several minority attorneys at the firm had experienced discriminatory treatment from colleagues but had been reluctant to report it for fear of being labeled as difficult or not team players. David realized that Victoria Walsh's behavior wasn't an isolated incident, but a symptom of broader cultural problems that had persisted despite his diversity initiatives. He commissioned an external investigation led by Dr. Patricia Williams, a former federal prosecutor who specialized in workplace discrimination cases. Dr. Williams' investigation revealed systematic issues that went beyond individual prejudices. Partnership track assignments showed patterns of bias, with minority associates receiving fewer high-profile cases and less mentorship from senior partners. Promotion rates for attorneys of color lagged significantly behind their white colleagues with similar qualifications. Client satisfaction surveys revealed that minority clients often felt unwelcome or questioned about their ability to pay the firm's fees. Business development data showed that the firm had failed to cultivate relationships with minority-owned businesses or diverse professional networks. Most troubling of all, the investigation found that Victoria Walsh's attitudes were shared by other senior staff members who had created an informal culture of exclusion that contradicted David's official diversity policies. Email reviews revealed coded language and private conversations that demonstrated bias in case assignments, client development, and partnership decisions. While the firm officially promoted inclusion, the day-to-day culture remained exclusionary in ways that were subtle but systematic. Dr. Williams' report concluded that Sterling and Associates had become a firm where discrimination was not explicitly endorsed, but was tacitly enabled through informal networks, subjective evaluation processes, and cultural assumptions that prioritized fit over merit. David realized that the issues went deeper than he had imagined, and he knew there was no simple fix. News of the incident broke 2 days later when a junior associate who had witnessed the confrontation contacted a reporter from the New York Law Journal.
The story quickly gained attention throughout the legal community, particularly when David's identity as the firm's managing partner and founding family member became known. Law firm partner ejected from own office read the headline in the American Bar Association Journal. The story was picked up by legal publications nationwide and eventually reached mainstream media outlets that recognized the broader implications of discrimination in the legal profession. The legal community's response was swift and largely supportive of David. Bar associations issued statements condemning workplace discrimination. Law school deans used the incident to highlight ongoing challenges with diversity in the profession. Legal aid organizations pointed to the case as evidence that bias persisted even in firms with official diversity commitments. However, some critics questioned whether David's response had been proportional to what they characterized as a misunderstanding. Conservative legal commentators suggested that Victoria Walsh had been unfairly punished for what they described as an honest mistake. David addressed these criticisms directly in an interview with the Legal Times. "This wasn't a mistake," he said. "It was discrimination. When someone assumes that a black attorney can't possibly be a partner at a prestigious firm, that's not confusion, that's bias. And when that bias affects how clients are treated and how business is conducted, it becomes a professional responsibility to address it." The interview was widely shared and quoted, sparking debates in law schools and bar associations about the persistence of discrimination in legal practice and the profession's responsibility to address it. The American Bar Association launched its own investigation into diversity practices at major law firms, using the Sterling and Associates incident as a catalyst for broader examination of bias in legal practice. The study revealed that David's experience was not unique. Discrimination against minority attorneys remained widespread despite decades of diversity initiatives. Statistics showed that black attorneys were significantly underrepresented at major law firms, particularly at the partnership level. Minority lawyers reported higher rates of discriminatory treatment from colleagues, clients, and opposing counsel. Client development opportunities were distributed unequally, affecting minority attorneys' ability to advance to leadership positions. The ABA's findings led to new professional responsibility guidelines that required law firms to actively address bias and discrimination. Bar associations began requiring continuing education on diversity and inclusion as a condition of maintaining legal licenses. Law schools updated their curricula to include more extensive training on recognizing and addressing workplace discrimination. Career services offices began tracking placement and advancement data by demographic characteristics to identify patterns of bias in hiring and promotion practices. Most importantly, the legal profession began acknowledging that diversity wasn't just about fairness, it was about competence. Firms with diverse leadership were more effective at serving diverse clients, understanding complex social issues, and avoiding the kind of blind spots that led to discrimination incidents.
David used the crisis as an opportunity to implement comprehensive reforms that went far beyond addressing Victoria Walsh's individual behavior. Working with Dr. Williams and other diversity experts, Sterling and Associates became a model for inclusive legal practice. First, the firm implemented blind review processes for case assignments, partnership decisions, and client development opportunities. Subjective assessments of fit were replaced with objective criteria based on legal skills, client service, and business results. Second,
Sterling and Associates established mentorship programs that paired senior partners with junior attorneys from underrepresented backgrounds, ensuring that advancement opportunities were available to everyone regardless of their personal networks or backgrounds. Third, the firm began actively recruiting clients from diverse business communities, recognizing that their client base had historically been too narrow and exclusive. Business development efforts were refocused on building relationships with minority-owned businesses, emerging companies, and organizations that reflected the full spectrum of American enterprise. Fourth, Sterling and Associates created accountability mechanisms that tracked diversity metrics at every level of the organization, from hiring to promotion to client satisfaction. Regular reviews ensured the progress was measured and maintained rather than assumed. Fifth, the firm established pro bono programs that specifically addressed civil rights and discrimination cases, using their legal expertise to advance social justice, while demonstrating their commitment to equality in practice rather than just policy. The changes at Sterling and Associates had immediate and positive effects on client relationships and business results. Companies that had previously felt excluded from elite legal representation began seeking out the firm's services. Minority-owned businesses found attorneys who understood their challenges and could provide effective advocacy. The firm's reputation for inclusive excellence attracted legal talent from top law schools who wanted to work in an environment that matched their values. Associate retention rates improved as attorneys from all backgrounds felt supported and valued rather than merely tolerated. Most importantly, the quality of legal representation improved as the firm's broader perspective and diverse expertise enabled them to better serve clients facing complex challenges in an increasingly diverse marketplace. Client satisfaction scores reached all-time highs, as Sterling and Associates demonstrated that excellence and inclusion were complementary rather than competing values. The firm began winning cases and attracting business that had previously gone to competitors. For David Sterling personally, the incident had been a painful reminder that his success and family legacy couldn't protect him from discrimination, but they could be powerful tools for creating change when used strategically and persistently. He continued leading Sterling and Associates with a deeper understanding of the subtle ways that bias could persist even in organizations with official diversity commitments. The experience had shown him that good intentions weren't enough. Systematic change required constant vigilance and active intervention. David also became more intentional about sharing his story with other legal professionals, recognizing that his experience could help address discrimination that other attorneys faced without the resources or influence to fight back effectively. He joined the board of the National Bar Association and worked with law schools to create pipeline programs that would increase diversity in legal education and practice. His message was consistent. The legal profession's credibility depended on its commitment to justice for everyone, including the attorneys who practiced it. Victoria Walsh's termination from Sterling and Associates effectively ended her career in elite legal practice. Word of the incident spread quickly through the legal community's informal networks, making her unemployable at other prestigious firms. She attempted to start her own practice, but potential clients were reluctant to hire an attorney whose judgment and professionalism had been so publicly questioned. Corporate legal departments that had previously retained her services quietly moved their business to other firms. The discrimination lawsuit that David and the firm filed against Victoria personally resulted in a settlement that funded legal education scholarships for underrepresented students. More importantly, her case became a cautionary tale throughout the legal profession about the career-ending consequences of allowing personal bias to override professional responsibilities. Victoria's fall of grace was complete and permanent. She eventually left legal practice entirely, carrying with her a painful understanding of how quickly prejudice could destroy a career that had taken decades to build. The Sterling and Associates incident created ripple effects throughout the legal profession that extended far beyond one firm or one case of discrimination. Law firms across the country began examining their own cultures and practices, fearful of facing similar incidents and reputational damage. Major firms implemented comprehensive diversity audits, updated their hiring and promotion practices, and established accountability systems that went beyond token diversity programs. The Sterling Standard became shorthand for legal practices that combined professional excellence with genuine inclusion. Legal education was also transformed as law schools recognized their responsibility to prepare attorneys for practice in an increasingly diverse profession and society. Clinical programs began focusing on bias recognition and inclusive client service as core professional skills. Bar associations updated their ethical guidelines to explicitly address discrimination and bias as professional responsibility issues. Continuing education requirements were expanded to include diversity and inclusion training as a condition of maintaining professional licenses. Most importantly, the legal profession began recognizing that diversity wasn't just about fairness. It was about competence and effectiveness. Firms with diverse leadership were better able to serve diverse clients, understand complex social issues, and avoid the blind spots that led to professional embarrassment and legal liability. 5 years after the incident in Sterling and Associates lobby, the legal profession looked fundamentally different. The combination of professional pressure, ethical requirements, and business incentives had created new standards for inclusive practice that benefited attorneys and clients from all backgrounds. David Sterling had used his experience to become a national leader in legal diversity initiatives. He spoke at law schools, consulted with other firms, and worked with bar associations to create systematic change that extended far beyond individual cases of discrimination. Sterling and Associates had become one of the most diverse and successful law firms in the country, attracting top legal talent who wanted to work in an environment that matched their values, while serving clients who appreciated both legal excellence and social responsibility. The firm's pro bono work had expanded to include landmark civil rights cases that advanced equality and justice throughout American society. David took particular pride in these cases, knowing that his firm was using its legal expertise to create the kind of world his grandfather had envisioned when he founded Sterling and Associates nearly a century earlier.
The law firm industry had evolved to embrace diversity, not as a compliance requirement, but as a competitive advantage. Firms that failed to create inclusive environments found themselves at a disadvantage in recruiting top talent, attracting diverse clients, and understanding the complex legal challenges of a diverse society. Legal education had been transformed as law schools recognized their responsibility to prepare attorneys for inclusive practice. Students learn not just legal doctrine, but cultural competence, bias recognition, and client service skills that enabled them to serve all clients effectively. Bar associations had updated their professional standards to make clear that discrimination wasn't just morally wrong, it was professionally incompetent.
Attorneys who allowed bias to affect their practice faced disciplinary action and potential loss of their licenses to practice law. Most importantly, the legal profession had begun to fulfill its promise as a defender of justice and equality, rather than just a protector of privilege and status. The changes that began with one incident of discrimination in one law firm's lobby had become a powerful reminder of how quickly assumptions could undermine the very justice that the legal profession was supposed to uphold. But they had also become proof that moments of injustice could be transformed into catalysts for professional transformation when people with influence chose to use their power responsibly rather than just protectively. David Sternin could have resolved the immediate situation quietly, ensuring better treatment for himself while leaving the discriminatory culture intact. Instead, he chose to use his position as managing partner to create changes that would benefit attorneys and clients who didn't have his advantages. That choice, between personal resolution and professional transformation, had rippled outward to create positive change that extended throughout the legal profession. Sometimes, the most powerful response to discrimination was not just seeking individual justice, but using that experience to build systems where discrimination became professionally impossible. The lesson of that Thursday afternoon in Manhattan had created changes that extended far beyond one law firm or one attorney's experience. Legal professionals learned to examine their assumptions and biases. Law firms learned that inclusion was not just morally right, but professionally necessary. The entire profession learned that its credibility depended on its commitment to justice for everyone, including the attorneys who practiced it. Because in the end, this story isn't just about discrimination in law firms. It's about the responsibility that comes with professional authority, the power of using personal experiences to create systemic change, and the understanding that true justice requires not just defending clients, but creating systems where everyone receives fair treatment. Every attorney deserves to practice in an environment free from discrimination. Every client deserves representation that is based on legal need rather than assumptions about worth. And every law firm has the power to choose between perpetuating bias and creating inclusive excellence that serves both justice and business success. If this story moved you, remember that the legal profession's promise of justice for all includes justice for the professionals who practice law. Share this story with someone who needs to hear it, and never forget that sometimes the most important case you can argue is the one for equal treatment and professional respect. Because the choice between accepting discrimination and fighting for equality is one that faces everyone who holds professional authority. The choice, as always, is ours to make, and the consequences ripple far beyond our individual careers to shape the entire profession and the society it serves.